Hello guys, welcome back to my channel Rahul Punand Study. In this video, we'll talk about a case, namely Bhaurao Shankar Lokhande versus State of Maharashtra. All India Report 1965 of Supreme Court. So guys, before move ahead, please subscribe this channel and press the bell icon to get notification on time. You can also get this video from my Telegram channel Rahul Punand Study. So guys, this case material provided by Delhi University for first semester LLB student. You can also open this case material while I am going to read the facts, judgment, consequences, issues of this case. So guys, after complete this case, we'll just learn about the some mechanism uses of the Hindu Marriage Act. So guys, its case about the bigamy. So let's read. Justice Raghubar Dayal gave their judgments about the fact of the case. Bhaurao Shankar Lokhande, the appellant number 1, okay, was married to the complainant in Dubai in about 1956. He married Kalabai in February 1962. During the lifetime of the in Dubai, Bhaurao Shankar Lokhande, appellant number 2, is the brother of first appellant, that is the brother of Bhaurao, the husband of Indubai, get married in 1956. Okay, just try to understand the fact of guys this case, so you will get the some result of this case. So try to make understand. Till here, just there is a Bhaurao Shankar, appellant number 1, and the Bhaurao's brother, namely Bhaurao Shankar Lokhande, appellant number 2, and the Bhaurao Shankar Lokhande married with Indubai in 1956 and again married with Kalabai in February 1962 after 6 years of first marriage in the life of Indubai. So let's read further. These two appellants, namely Bhaurao Shankar Lokhande and their brother, namely Bhaurao Shankar Lokhande, together with Kalabai and her father and accused 5, okay, a barber, were tried for an offence under section 494 of IPC. Okay. Okay. Kalabai also came into matter because the second wife of the Bhaurao Shankar Lokhande and Indubai is the first wife of Bhaurao Shankar Lokhande. Hence, the Indubai's marriage was valid. Then, the second marriage will came into matter for bigamy. That's why Kalabai is charged or became the accused here. Okay, continue. We tried an offence under section 494 of IPC. The later 3 were acquitted by magistrate. Appellant 1 was convicted under section 494 IPC and appellant 2, that is Bhaurao Shankar Lokhande, Appellant number 2 for an offence under 494 read with section 114 of IPC. Their appeal to the session judge was dismissed. Their appeal to session judge was dismissed. Their revision to the High Court also failed. They have preferred this appeal by the special leave granted under the section 136 of Supreme Court. So, okay. Okay, there were five accused as per the fact of this case. Two appellant also came into force or came into matter still, or three accused as were acquitted by the magistrate. Okay, next, the only contention raised for the appellants is that in law it was necessary for the prosecution to establish that alleged second marriage of appellant 1 with Kalabai in 1962 had been duly performed in accordance with the religious rites applicable to form of marriage gone through. It is argued for the appellants that essential ceremonies for a valid marriage were not performed during the proceeding which took place when appellant 1 and Kalabai married each other. On behalf of the state, it is argued that proceedings of that marriage were in accordance with the custom prevalent in the community of the appellant for the Gandharva form of marriage, and that therefore the second marriage of appellant 1 with Kalabai was a valid marriage, Gandharva form of marriage. It is also urged for the state that it is not necessary for the commission of offence under section 494 IPC that the second marriage is be valid one. Okay. Prime facie by the very fact, the expression whoever marries must mean whoever marries validly, or whoever marries and whose marriage is a valid one. If the marriage is not a valid one according to the law applicable to the parties, no question of its being void by reason of its taking place during the life of the husband or wife of the person marrying arises. If the marriage is not a valid marriage, it is not marriage in the eye of law. The bare fact of a man and a woman living as a husband and wife does not at any rate normally give them the status of the husband and wife, even though they may hold themselves but before society as husband and wife, and the society treats them as husband and wife. Okay, apart from this consideration, there is nothing in the Hindu law as applicable to marriage till the enactment of the Hindu Marriage Act of 1955, which made a second marriage of a male Hindu during the lifetime of his previous wife fight. Okay. Section 5 of the Hindu Marriage Act provides that a marriage may be solemnized between any two Hindus if the conditions mentioned in the section are fulfilled. The condition as there should be there are no spouse of any of the party. There should be the capable person. There should be not incapable person to know about the unable to know about the performance of the act, what is going on between to them. This type of there is other also condition like there is no relationship with prohibited degree. There are approx 9 condition provided under section 5. You can also refer the barracks of Hindu Marriage Act section 5 to clear about the condition of Hindu Marriage Act. Okay, continue. Act provides that a marriage may be solemnized between any two Hindus if the condition mentioned in that section are fulfilled, and one of those conditions is neither party has a spouse living at the time of the section marriage. Okay. Section 17 provides that any marriage between two Hindus solemnized after the commencement of the act is void if at the date of such marriage either party had a husband or wife living, and that the provision of the section 494 and 495 of IPC shall apply accordingly. The marriage between two Hindus is void in view of section 17 if the two conditions are satisfied. The marriage is solemnized after the commencement of the act. Okay. At the date of such marriage, either party had a spouse living. If the marriage which took place between the appellant and the Kalabai in February 1962 cannot be said to be solemnized, that marriage will not be void by the virtue of section 17 of the Act, and the section 494 IPC will not apply. Okay, to such party to the marriage as had a spouse living. The word solemnize means in the connection with a marriage, to celebrate the marriage with proper ceremonies and in due form according to the Shorter Oxford Dictionary. Okay, it inflows therefore that unless the marriage is celebrated or performed with the proper ceremony and due form, it cannot be said to be solemnized. It is therefore essential for the purpose of section 17 of the Act that the marriage to which section 494 of IPC applies on account of provision of the Act should have been celebrated with proper ceremonies and in due form. Merely going through contents ceremonies with the intention that the parties be taken to perform will not make them ceremonies prescribed by the law or approved by any established custom. We are not opinion that unless the marriage which took place between appellant 1 and Kalabai in February 1962 was performed in accordance with the requirement of the law applicable to a marriage between the parties, the marriage cannot be said to have been solemnized, and therefore appellant 1 cannot be held to have committed the offence under the section 494 of IPC. We may have now determined that the essential ceremonies for a valid marriage between the parties are: it is alleged for the respondent that the marriage between appellant 1 and Kalabai was in Gandharva form as modified by the custom prevailing among the Maharashtra. It is noted in the Mullah's Hindu's Law, 12th edition, at page number 605. The Gandharva marriage is the voluntary union of a youth and the damsel, which springs from the desire and the sensual inclination. It has been erroneously described as an euphemism for concubinage. This view is based on a total misconception of the leading text of the Smritis. It may be noted that essential marriage ceremonies are as much as a requisite part of this form of marriage as of any other, unless it is shown that some modification of those ceremonies has been introduced by custom in any particular community or caste. At page 1615 is stated, there are two ceremonies essential to validity of marriage, whether it marriage be in Brahma form or in Ashura form, namely inno, invocation before the sacred fire, Saptapadi, that is taking of seven steps by the bridegroom and the bride jointly before the sacred fire. A marriage may be completed by the performance of the ceremonies other than those referred in the subsection 1, where it is allowed by the custom of the caste to which the party belong. It is not disputed that these two essential ceremonies were not performed when the appellant one married with Kalabai in February 1962. There is no evidence on record to establish that the performance of these two essential ceremonies has been abrogated by the custom prevalent in their community. In fact, the prosecution laid no evidence as to what the custom was. It led to evidence of what was performed at the time of the alleged marriage. It was the counsel for the accused in the case who questioned certain witnesses about the performance of certain ceremonies, and to such question the witness replied that they were not necessary for the Gandharma form of marriage. In their community, such a statement does not mean that the custom of the community deemed what took place at the marriage of appellant 1 and the Kalabai sufficient for a valid marriage, and that the performance of the two essential ceremonies had been abrogated. There ought to have been definite evidence to establish that custom prevalent in the community had abrogated these two ceremonies for such form of marriage. What took place that night when appellant 1 married Kalabai has been stated thus by page plaintiff witness number 1. The marriage took place at 10 p.m. PAT. Wooden seats were brought, a carpet was spread, accused 1 then sat on the wooden seat. On the other seat, accused 3 sat. She was sitting nearby accused 1. Accused 4 then performed some puja by bringing a tambaya pitcher, betel leaves, and count's coconut was kept on the tambaya. 2 garlands were brought. Accused 2 was having one and accused 4 having one. In his hand, accused 4 gave the garland to the accused 3 and the accused 2 gave the garland to the accused 1. Accused NOS, accused notes 1 and accused numbers 1 and 3. Then the garland each other. Then they each struck each other's forehead. In a cross examination, this witness stated, "It is not that the Gandharva, according to our custom, is performed necessarily in a temple. It is also not that a Brahmin priest is required to perform the Gandharva marriage. Number no Mangala Astakas are required to be changed at the time of the Gandharva marriage. At the time of the marriage in question, no Brahmin was called and the Mangala Astakas were chanted. There is no custom to blow a pipe called Sher in vernacular." Sitaram, witness number 2. Witness 2 for the complaint made a similar statement about what happened at the marriage ceremony and the further stated in the examination in chief. Surpan, in the village of accused three's maternal uncle, as the custom is not to perform the ceremony at the house of maternal uncle, so it was performed at the another place. There is no custom requiring a Brahmin priest at the time of the Gandharva. He stated in a cross examination a barber is not required and accused 5 was not present at the time of the marriage. There is a custom that the father of girl should make to touch the foreheads of the girl and the boy each other, and the Gandharva is completed by the act. Okay, it is urged for the respondent that as the touching of the forehead by the bridegroom and the bride is stated to complete the act of the Gandharva marriage. It must be concluded that the ceremonies which, according to this witness, had been performed, were all the ceremonies which by custom were the necessary for the validity of the marriage, in the absence of the statement by the witness himself that according to the custom these ceremonies were the only necessary ceremony for a valid marriage. We cannot construe the statement that the touching of the foreheads completed the Gandharva form of marriage and that the ceremonies gone through the where all the ceremonies required for the validity of marriage. Bhagwan, witness number 3, for the complainant made no statement about the custom but stated in a cross examination that it was not necessary for the valid performance of Gandharva marriage in their community, that a Brahmin priest was required and Mangala Astakas were to be changed. The statement of Jibhau, witness number 4 of the complainant, does not show how the custom has modified the essential form of marriage. He stated in a cross examination, I had witnessed to Gandharvas before this for the last 5 or 7 years. At a Brahmin priest, a barber, and a Thakur is not required to perform the Gandharva, but formerly it was essential. Formerly, the Brahmin used the chant Madras and the Mangala Astakas. It was necessary to have the maternal uncle or any other person to make touch the forehead of the sponsors together. A Brahmin from Kasara and Dhandana comes to our village for doing rituals, but I don't know their names. This statement too does not establish that the two essential ceremonies are no more necessary to be performed for a Gandharva marriage. The fact that they were probably not performed in the two Gandharva marriage Jibhau had attended does not establish that their performance is not more necessary according to the custom in that community. Further, Jibhau has stated that about 5 or 7 years earlier, the performance of certain ceremonies which still then were essential for the marriage were given up. If so, the departure from the essentials cannot be said to have before become a custom as completed by the Hindu Marriage Act. Clause A of the Section 3 of the Act provides that the expression custom and usage signifies any rules which, having been continuously and uniformly observed for a long time, has obtained the force of law among the Hindus in any local area, tribe, community, group of or family. We are therefore opinion that the prosecution have failed to establish that the marriage between the appellant 1 and Kalabai in February Itna was performed in accordance with the customary rights as required by the Section 7 of the Act. It was certainly not performed in the accordance with the essential requirements for a valid marriage under the Hindu law. It follows, therefore, that the marriage between the appellant 1 and Kalabai does not come within the expression solemnized marriage occurring in the section 17 of the Hindu Marriage Act, and consequently does not come within the mischief of section 494 of IPC, even though the first wife of appellant was living when he married Kalabai in February 1962. We have not referred to the discuss the cases referred to the support to the contention that the subsequent marriage referred to the section 494 of IPC need not be a valid marriage, as it is unnecessary to consider whether they have been correctly decided. In view of the fact that the marriage of appellant 1 with the Kalabai could not be void marriage only if it came within the purview of section 79 of the fact of the act, could be void marriage only it came within the purview of section 17 of the act. The result is that the conviction of appellant 1 under the section 494 of IPC and of appellant 2 under the 494 read with section 114 of IPC cannot be sustained. We therefore allow there the appeal, set aside for the conviction and acquit them. The bail bonds of the appeal 1 will stand discharged. Fines, if paid, will be refunded. Thank you. So, guys, this is the case about the whether a marriage is void, and if the second marriage is void, then there is no applicability of the bigamy. As you can see that the case, there should be the both marriage be valid for applicability of the bigamy. So guys, thank you so much for watching this video. I hope this video will help you the meaning to understand the meaning of solemnization in marriage and the bigamy, when bigamy happened or not. So guys, thank you so much for watching this video. Bye bye, take care, have a nice day.